Good afternoon. I would like to thank you on behalf of the Tsatsos Foundation for participating in this conference. It is a joy and it is an honor to be your host. Our topic, populism and the rule of law, is painfully relevant. Crisis after crisis, we've come to realize that we must always remain alert to threats against the rule of law. The dark side of populism is a slow burn phenomenon. Culture wars, to refer to Mark Tushnet, are never over, as we witnessed in the recently leaked Roe overturn. And yet, are we ready to give up on popular participation? I hope we shall have a challenging discussion. I shall briefly introduce our guests, whose work I very much admire, must admit. So we have Paul Blokker, who's an associate professor of public law at the Department of Sociology and Business Law at the University of Bologna. He's done extensive work on participation and the rule of law. Catarina Santos Botelho is professor of law at the Porto Faculty of Law and has extensively written on many topics of rights and the rule of law. Andreas Haratsch is co-director of the Dimitris Tsatsos Institute for European Constitutional Studies. We're very honored to have you here. He's the chair of German and European Constitutional and Administrative Law, as well as Public International Law at the University of Hagen. Professor Tomasz Koncewicz is director of the Department of European Comparative Law at the University of Gdańsk. And most of us, I think, are familiar with his work on backslide. And Kostas Botopoulos holds a doctorate in constitutional law, is the former chairman of the Hellenic Capital Markets Commission and the former member of the European Parliament. So without delay, I will ask you to abide by the time limits to the degree possible, and I will pass the virtual floor to Paul Blokker. Paul.
Thank you so much. Thank you for your kind words, and thank you for your invitation in this really important event. I'm going to share my screen. I hope you can see the slides. My talk will be particularly focusing on, in a way, on rethinking how we approach the rule of law in relation indeed to issues like backsliding, but also in a wider sense. I think many European societies show problems, tensions around the rule of law. And so what I will briefly suggest is the standard argument about the rule of law takes the rule of law largely as a from above type of idea. It conceptualizes the rule of law in a kind of institutional sense. And my argument will be that we ought to at least go into a parallel argument, a very much related argument, and that is the rule of law from below, the rule of law as a kind of language grammar within society as such. So that will be one argument about how we need to understand the rule of law if we want to protect the rule of law. A second related issue then, which I will briefly mention, is a democratic understanding of the rule of law, which has very much to do with citizen engagement actually with the law itself and the configuration of the law. Then I will end on a slightly more problematic note, to which I don't really have an answer, I have to say, and that is attention to society, attention to civil society, attention to the progressive forces of society also needs to take into account counter examples, society that manifests itself in a way that is very much in contrast with what we normally understand by the rule of law. So very briefly, much of the rule of law instruments that we use, much of the rule of law policies that we see tends to take the rule of law largely as a language, a grammar, a set of instruments that relates to institutions, to the functioning of institutions, to, for instance, as a core principle, separation of power, holding institutions accountable, emphasizing legality, and so on and so forth. And in that argument, in that narrative, it is states, it is institutions, it's formal political, juridical institutions, as well as international institutions that are seen as the guardians of the rule of law. And so our attention tends to be on the protection of the rule of law through those institutions, and hence the protection of those institutions themselves. And so the rule of law becomes a kind of instrument of institutional architecture, institutional engineering, and a kind of what you could call the grammar of governance. And we see this, I think, also in many ways in the various indices and checklists that quantify, in a way, how we understand the rule of law and how we understand whether the rule of law actually functions. This is a partial view, in my understanding, of what the rule of law is. In a radical sense, and I should actually mention that I'm a sociologist, I'm not a lawyer by training, in a sociological sense, which in my view is the correct way of looking at things, law, including the rule of law, of course, is part of a set of societal functions. It has a societal role. The law in itself doesn't mean much. It has a series of functions in terms of integrating society, in terms of making society work properly, in terms of avoiding conflict, etc. So law is a social fact, and we hence need also to understand the rule of law from that type of perspective. It relates to the institutions, it's a core dimension of the institutions, but equally it is a societal language, where it ought to be a societal language. That means both we need to pay attention to active engagement of societal forces, which we normally relate to civil society, but we also ought to take into account that silent majority that hardly seems to be explicitly engaging with the law, and that is indeed the largely passive citizenry. And so my claim would be we need to, and it's of course not only my claim, as you can see from the references on this slide, we need to broaden up our understandings of the rule of law. We need to try to get a firmer grasp and grip of how society actually engages with the law. And this is in many ways, I think, a fundamental question, because it's very unlikely that if we have merely rule of law institutions, that the rule of law will function, that it will be effective, that it will be sustainable in the longer run. And so society should be an object of our focus in various manifestations. Of course, the most visible ones are those actors in society that are active, social movements, NGOs. Also, of course, we should pay crucial attention to the media as a kind of rule of law watchdog in many ways. And even academic institutions can be included in this dimension. And there's a whole range of fundamental activities such actors engage in, like indeed monitoring violations of the rule of law, violations of human rights, manifesting explicit protests, like you can see on this slide in the Romanian case, in favor of the rule of law, in favor of upholding the rule of law, upholding the human rights regime, you might call it like that, and hence also contributing to a kind of publicity of issues around the rule of law, contributing to the development of a public space in which the rule of law becomes a matter of great importance. And then, of course, there are also the much more, in a way, technical legal dimensions that relate to advocacy, that relate to explicit practices of litigation, and even what you could call, in certain ways of understanding the notion, what you could call lawfare. Actually, in many ways, and I'll come back to that, conflict over the rule of law and human rights within society as such. So this is a crucial dimension, I feel, also when we address the whole issue of backsliding. I mean, to simplify, one clear dimension of backsliding is the fact that societies don't tend to stand massively up in favor of the rule of law. And hence, political pundits can take over without much reaction from society. I could make a much longer historical argument about this, relating it to 1970 dissidents, etc., but I won't because I don't have the time. Let me get to a second dimension of what I would like to argue today, and that is a related dimension, but not exactly the same, is a democratic understanding of the rule of law. Again, in much of the official, formal political, let's say, if we focus on the European Union, the EU's approach to the rule of law, we see a tendency to indeed an institutional approach, which tends to conflate the rule of law with democracy. And so the argument almost becomes, if we manage to solidly institutionalize the rule of law, that, well, then democracy will follow more or less by itself. And so the rule of law is very much an institutional asset in this reading. One could even understand the European integration process as a kind of integration through the rule of law, as Kuhn-Lennartz has called it, and others as well, of course. And so from that perspective, the rule of law becomes a kind of institutional policing, in the case of the European Union, of its fundamental values as stipulated in Article 2 of the Treaty on the European Union. And there's much less attention to, let's say, the other, the more bottom-up dimension of engagement, elaboration of the rule of law within societies as such, activities of promoting, etc. And so I have already, of course, mentioned the societal dimension, but the further argument here is that the democratic understanding of the rule of law would not only need to stand still by the idea that society needs to use the rule of law, it needs to use the instruments of the rule of law to defend the rule of law itself, but it should actually democratically be participating in the formulation of law. And so this is very much an argument along the lines of democratic participation, of citizen engagement, which is not necessarily entirely the same as rule of law engagement by civil society, often professionalized civil society actors. And so a democratic rule of law then goes much beyond the checklist type of approach, a minimalist and institutional type of approach. And it looks at the rule of law as indeed a more kind of virtuous circulation of the rule of law throughout society, which includes then active engagement of citizens with the formulation of what the rule of law actually means. What are the key issues to be addressed when we talk about backsliding, when we talk about distrust in judicial institutions, and so on and so forth. And so a societal type of counter-democracy then would need to recognize citizens as full-blown agents, and in a way as co-owners of the issue of the rule of law. And here on the slide, you see a bit of a sort of visual brainstorming about what kind of guise this could take within the European Union's context. In some ways, the Conference on the Future of Europe, which is now ending on Monday, addresses some of the issues, for instance, by discussing notions of access to justice, participatory assemblies, etc. And I also mention here the Reconnect project, which was a Horizon 2020 project, which addressed these issues head on. For instance, recommending a broader access to the Court of Justice of the European Union as one way of indeed expanding a democratic understanding of the rule of law. Here's another elaboration that I elaborated indeed in the Reconnect project. In a deliverable, if you want to look at it, you can find it on its website, where indeed I identify a number of dimensions of what a democratic rule of law could mean in practice. It's about access to justice, it's about forms of consultation, but also perhaps co-decision making, various forms of citizen participation, and forms of expanding a democratic rule of law culture throughout society. My time is running short, so now I get to where I'm sort of stuck, I have to say, because if we look honestly at civil society, we have to acknowledge that there are very important and very well organized parts of civil society, what some call uncivil society, that equally use the law, that equally use instruments like litigation, amicus curiae to national and European courts, and so on and so forth, that take a slightly different approach and that back up those projects that we are identifying as backsliding. So there is a conundrum here. On the one hand, my argument has been very much in favor of expanding capacities in civil society in order to uphold the rule of law, but this would equally, in certain ways, support potentially problematic engagements with the rule of law. And I will just have to leave you with this problem, which, as far as I can see, has not been extensively addressed yet in academic research as a potential conundrum, indeed, of a democratically and societally functioning rule of law. So I will stop there, and I hope we will have a fruitful discussion on these matters. Thank you very much.
Thank you, Paul. I must confess that it was one of the things you had said early on in our research on participatory constitutional change that had triggered Professor Contiades and my decision to work on a constitution watch, Syntagma watch, because you said we must educate, we must do something about citizens. So do what? So we decided to act. So we've created through the center this watch where citizens actually can find everything from short lessons on constitutional law to answers. They even can submit questions. And it's very odd and expected perhaps that everything that has become a constitutional controversial issue in the latest 2 years, and imagine with the pandemic how many those were, we had questions from citizens answered by top academics, by judges, etc. So with this question, the rule of law and democracy, it is a very odd relationship. Does democracy always lead to the rule of law and vice versa? Can we have rule of law without democracy? I don't know, a very difficult question to answer. With this, I will pass the floor to Catarina Santos Botelho. Catarina, you have the floor.
I want to greet the chair and the co-panelists and the audience. In the face of the rising populism and extremism, should democracy be neutral or militant? I will focus my brief presentation on political parties and constitutions. Elkins wrote that the regulation of parties is a dangerous game, one played both by democracies and non-democracies alike. The experiences of the world wars brought political and legal consequences regarding political parties and the invasion of democracy per se. One of the most vicious faces of Nazism, Joseph Goebbels, ridiculed the Weimar legal arena while declaring that this will always remain one of the best jokes of democracy, that it gave its deadly enemies the means by which it was destroyed. Following the resistance to totalitarianism and authoritarianism, democracy could hardly become an agnostic or relativistic concept. Of course, all political parties aim at conquering power. However, some use the legal arena to later fulfill their illiberal or anti-democratic agendas. In the first half of the last century, Karl Löwenstein wrote his famous militant democracy approach to fascism, arguing that fire should be fought with fire. In this sense, legal orders should ensure that the enemies of democracy will not be able to exploit the freedoms inherent to democracy. Joining this never again mentality, Karl Mannheim, another German of Jewish origin exiled in the US, offered his sociological diagnosis in the reflection, The Third Way, a Militant Democracy. He clearly wrote that the principle of laissez-faire will not help us any further, and that our democracy has to become militant if it is to survive. In this sense, he believed that it was possible to create a pioneering and militant type which is not fanatical, an emotional type whose emotions, and we very well know how emotions are important in populism, but these emotions would be more than displaced fears. Jurisdictions that have not experienced totalitarianism and authoritarianism might be warier of the militant democracy model. In fact, the American scholarship considered the concept of militant democracy one of the most startling aspects to an observer of the other side of the Atlantic. On the contrary, others fail to see the validity of militant democracy in contemporary societies. This concept raised acute critique. Some label militant democracy as paternalist, since it treats the electors as incapable of determining for themselves the merits of different positions and eliminates public discussion on all political perspectives. So it deprives people of effective citizenship. Others argue that there is an irreducible element of arbitrariness when deciding who are the enemies of democracy. There are also strong reasons grounded within philosophical liberalism that advocate against outlawing political parties, for instance, on the basis of their ideology only. To Mueller, militant democracy cannot be legitimized or normalized as it requires the use of illiberal measures. Others argue that instead of excluding problematic parties, these parties should be welcomed in the democratic arena with hopes that they will become more moderate. So the parties should offer better arguments so that the people won't vote in these very extremist parties. We know that political parties are crucial to the democratic system. At best, party bans proscribing parties is the most visible form of preemptive defense to the political rights of the future generation. At worst, party bans are a form of tyranny. In post-war European constitutional history, the most muscular forms of militant democracy, which are party bans, but there are other aspects such as states of emergency, eternity clauses, and so on, were beforehand an instrument of symbolic politics. As we will see, as the democratic consolidation progressed, some high courts decided not to ban parties of marginal political relevance. This is also the guideline of the Venice Commission on the prohibition of the dissolution of political parties. It says that prohibition should be used with the utmost restraint, so they recommend parsimony and, as far as possible, a less radical measure than banning political parties. So I will now briefly address three cases: Germany, Israel, and Greece. So Germany, the German constitution, as we all know, it has a lot of militant traits. The Socialist Reich Party in 1953 was prohibited. It was a party with a neo-Nazi orientation. The Bundesverfassungsgericht, the German Federal Constitutional Court, considered that this exclusion was justified because the supreme fundamental values of liberal democracy were at stake. So, and this party had an undemocratic and racist political agenda. Contrary to Austria or Portugal, in which respectively only neo-Nazi or in Portugal only fascist parties were prohibited, in Germany the pendulum swung back and forth to the extreme left and to the extreme right. So the first dissolution was of the extreme right party. The second dissolution, and this was highly more polemical, was on the Communist Party. So this was one of the longest opinions of the Bundesverfassungsgericht, almost 1,308 pages. And the court found that the ultimate goals of the party which was proletarian dictatorship and revolution, were incompatible with the free democratic basic order. But what was curious was that the Communist Party had only 2 points in the popular vote for the Bundestag election and was not a menace at the time of its banning. In the 2 following cases regarding the proscription of political parties, it was the radical groups case in which 3 radical left-wing parties were denied campaign broadcasting in some German states. The court decided that such denial threatened the principle of equality of opportunity granted to every political party. So dismissed the case. The second case, it was also dismissed. It was the case of the extreme right-wing party, National Democratic Party. And as this party had a shy parliamentary representation and declining membership, its actions would not succeed in mobilizing the right-wing extremist movement. So this is interesting because the Federal Constitutional Court went from a sheer militant democracy stance to a more mitigated or rhetorical resort to militant democracy. So one can wonder if this means that this has something to do with the evolving maturity of Germany's democracy. Regarding the Israel case, this is quite an astonishing case because in Israel, there is this paradox. On the one hand, the basic law and the ordinary law, the party's law, militantly allow an easy disqualification of terror-supporting parties. Bans can be approved merely for illegitimate political speech. But on the other hand, though, the Supreme Court of Israel adopts a neutral stance, does not adhere to the legal militant democracy model, and states that proscribing of political parties must be reserved when there is unequivocal proof of terroristic actions, in line with the jurisprudence also of the European Court of Human Rights. The Greeks, the example of the Greek, I think is relevant for, we all know that for historical reasons, the Greek constitution does not allow the dissolution of political parties. Party banning recalled the memory of anti-communism and dictatorial oppression in Greece. But the Golden Dawn case provoked a renewed interest in whether it would be wise to introduce militant democratic provisions. Golden Dawn in 2012 won 21 seats in parliament. And how did the Greeks solve this problem? Well, instead of a constitutional issue, they transformed this problem they dealt with extremism within political parties by a nexus of criminal and administrative law. So political measures were adopted to tackle racist violence, such as creating special units within the police. There were criminal proceedings that took place against the Golden Dawn, and in 2020, several members of the Golden Dawn and the leadership were ruled jail sentences for all defendants. And there was also rules for public funding of political parties that were amended to incorporate a temporary suspension of financial support in the event of criminal prosecutions. So as we have a little time, and to conclude, illimited relativism, or as I prefer to call it, the absolutism of relativism, can challenge the enforcement of human rights and the quality of democracy. Social inequalities, corruption, and populism are so very much a threat or even a reality, even in the so-called consolidated democracies. The democratic project is perhaps never entirely fulfilled. And during the first half of the last century, when addressing the peoples of the subjugated countries of Europe, many intellectuals believed that only militant democracy could win this war, which, after all, is a war of ideas. Strict procedural democracy is an unsatisfying response. Merely striking down militant democracy without offering alternatives is a form of political quietism, and I'm citing Schuppmann. militant democracy and party banning might not be the most, intellectually sophisticated and normative dense strategy to restrain illiberal democracy, but at least it offers a solution, even if it is a fragile solution. There is, it concludes, there is a symbiotic relationship between democracy and parties. We need democracy in order to maintain parties, and we need parties in order to maintain democracy. Perhaps we should wonder if political parties exist within evolving societies. It means that political parties themselves can evolve. Thank you so much.
Thank you so much, Catarina. That was so interesting. And I'm thinking that perhaps we should focus more on emotions and their relation to constitutional politics and politics at large. I mean, after so many crises, the pandemic, the financial crisis, I think that emotions do play a more important part in constitutional politics and the way we decide. Now, if I'm allowed to comment on the Golden Dawn, we were in luck because they were actually a criminal organization. So it was possible, although I'm happy that they were won through elections. Nonetheless, they were not just of neo-Nazi ideology. They were actual criminals. The question thus remains, what would have happened if they were not actual criminals, if they did not act on their Nazi ideas, but we had to just deal with a political party with an ideology that were not actually killers, murderers, criminals? That's a question that remains open. So with this, I will pass the floor to Professor Haratsch. Professor Haratsch, you may start.
Yeah, thank you very much for inviting me. So I'm able to talk to you all on this very serious and important topic. I'm going to focus on the contradictions between modern populism and the democratic rule of law. And I've prepared a slide containing the table of content. So I'm going to share it with you. I hope it's going to work. Yes, it does. So I hope you can all see it. And so let's start. Over the last few decades, so-called populist parties have gained political influence in almost all Western democracies. That's why we're here today and talking on this topic. In some states, they have succeeded in participating in government or even in forming it alone. In Germany, too, a populist party has established itself over the past 10 years, calling itself Alternative for Germany, in German Alternative für Deutschland, or short AfD. The party had started in 2013 as an EU-skeptical right-wing liberal party. It had emerged from a protest movement directed against the introduction of the euro as a currency. But in recent years, a far-right nationalist current has gained the upper hand within the party. Several of the regional associations have been under surveillance by various state agencies for the protection of the constitution since 2018. In 2020, just some weeks ago, the Cologne Administrative Court ruled that the federal agency for the protection of the constitution may classify the entire party as a suspected right-wing extremist case and observe it. Nevertheless, the AfD achieved a share of 10.3% of the vote in the 2021 federal election and showed a strong result, especially in East Germany. So after these introductory remarks, let me say some words on the concept of populism. Populism can appear in different forms and can take on different shapes. A closer look reveals that it is not an ideology in the classical sense, such as communism, socialism, or liberalism. Populism is not necessarily right-wing populism. On the contrary, there are also left-wing manifestations of it. Populism as such has no real substance. It is a thin-centered ideology that is necessarily attached to an existing set of other ideas. In other words, populism always needs a kind of host ideology. Paul Taggart calls this the empty heart of populism, which gives it weakness on the one hand and potential ubiquity on the other. However, this observation does not absolve us from the search for a definition of the phenomenon. According to the most widely used dictionary of the German language, populism means a popular, often demagogic policy characterized by opportunism, which aims to win the favor of the masses with a view to elections by dramatizing the political situation. Such an understanding of the term still remains vague and only gives us some indication of the characteristics of populist movements in today's political landscape. But at least this definition reveals that populism is a strategy for the purpose of acquiring and maintaining political power. In spite of its emptiness in terms of content, populism can be recognized by a certain characteristic feature. The basic trait common to almost all populist currents of today is the idea of a morally pure, homogeneous people always confronted with immoral elites who do not actually belong to this people. The elites are seen as corrupt, duplicitous, parasitic, self-serving, and arrogant. This basic trait of populism must be in tension with the democratic rule of law. The first anti-democratic feature of populism is the rejection of a free democratic and pluralistic discourse. Populists claim to have recognized the one true will of the people and are therefore the only ones really entitled to speak for the people. It is significant that populist parties want to avoid being called a party. The term would reveal that they are only a part of the whole, but not the whole itself. Instead, such terms as movement, front, rally, or in French, rassemblement, or alternative are preferred. The populist identitarian claim is inherently anti-pluralistic. A party program guided by the will of the people and which is actually identical with it does not have to face any democratic discourse. The claimed moral superiority relieves their views of any need to justify themselves. Democratic struggle for the best solution in the interest of the common good is thus dispensable. But it is exactly this discursive search for the best solution which is one of the central characteristics of democracy, since no one can claim to know what the common good is. Respect for others in their political convictions, openness to argumentation, and compromise are crucial elements of democratic procedures. Closely linked is a second characteristic element of populism, which is the negation of the legitimacy of democratic majority decisions. Populists live in a universe of alleged self-evident facts. The basic axiom is the appeal to common sense, which is supposed to be superior to the reflective knowledge of intellectuals because it is based on real-life experience, so at least they say. As they pretend to possess a higher knowledge, not only of the true will of the people, populists can do without the integrating and transforming power of a democratic parliament. In addition, populists see parliaments as instruments of power of an elitist establishment. Instead, they advocate an allegedly unfiltered articulation of the political will of the people in the sense of a spontaneous democracy of acclamation. With this narrative, populist movements are trying to break the bond between the rule of law and the will of the democratic majority. However, In a parliamentary democracy, the people perform their influence on the exercise of state power through elections. There must be this indispensable democratic link between the people, the parliament they elect, and the laws passed by that parliament. The participation of citizens in the formation of the state's will, of course, is not only limited to the act of voting. Rather, it is a steady process in which in a constant discourse, the political parties shape the decisions in the institutions, especially in parliament. This process results in a democratic majority decision that must be respected by all. A third characteristic feature of populism is the rejection of the idea of the free mandate of members of parliament. According to Article 38, paragraph 1 of the German Basic Law, the members of the German Bundestag are not bound by any orders or instructions and are responsible only to their conscience. This is in stark contrast to populist ideas. Based on the populist axiom of a unified single people's will that exists at all times and on every single issue and that is easily recognizable, populists claim that members of parliament simply always have to follow this will. This idea, of course, is inaccurate because this alleged unified will of the people does not and cannot exist. Politicians who claim this, however, conceal the fact that it is they themselves who pre-formulate a supposed popular mandate and who, for their part, can only be interpreters of certain ideas and interests. Moreover, since members of parliament are only subject to their conscience, they must not evade their personal political responsibility by appealing to an alleged will of the people. Parliamentary democracy can only function through the free mandate. The independence of parliamentarians leads to the necessity of having to use arguments to win approval for a particular legal measure. This is the only way to create a democratic discourse, a struggle for the common good. A fourth characteristic of populism is the ostracizing or outlawing of opposition. This is evident wherever populists have come to power. Beyond the legitimate occupation of political key positions, their aim is the fullest possible seizure of all state offices and to marginalize the opposition. Parliamentary or extra-parliamentary control, for example by the media, is denounced as being directed against the people. You will all remember Donald Trump's remark calling journalists enemies of the people. Nor should we forget the statement of Recep Tayyip Erdogan, who in reaction to the protests on Taksim Square and in Gezi Park in 2014, and with a view to the opposition, shouted out, "We are the people, who are you?" What these statements have in common is that whoever is against them, that is, whoever forms an opposition, cannot be part of the people. However, the right to organized and effective political opposition is rooted not only in the principle of democracy, but also in the rule of law. While the democratic principle only allows for power for a limited period of time, and the opposition must therefore have the possibility of coming to power itself, the rule of law, with its element of separation of powers, aims at a system of checks and balances. Hence, an effective political opposition is indispensable in such a system. The fifth and final distinctive feature of populism is the elimination or at least weakening of judicial review. The quest for complete seizure of all state offices by populists who have come to power also includes the judiciary. Poland is a cautionary example in this respect. Behind this is the idea that the reign of judges should not obstruct the realization of the true will of the people. This populist view is wrong for two reasons. Firstly, court decisions are not undemocratic in themselves. Courts implement the democratic will as their judgments are rendered in the name of the people. Secondly, democracy does not assume that a democratic decision is right, just, or at least reasonable. Of course, one might argue that an open discourse inevitably favors arguments that are more reasonable and leads to correct and just decisions. Yet, this line of argumentation presupposes that there is something like an objective reason or a common sense, as populists claim, and that voters or members of parliament feel obliged to it. In addition, parliaments and governments are fallible. The democratic rule of law assumes that mistakes will happen and that they must be corrected. Restrictions imposed on a government or a parliamentary majority for reasons of the rule of law do not contradict the principle of democracy, but are an expression of a self-restraint inherent in the democratic principle itself. We are dealing with the democratic rule of law. As this very condensed and certainly not exhaustive analysis has shown, populists pose a serious threat to democracy and to the rule of law that should not be underestimated. The vocabulary of populists is bursting with democratic terms as they claim to be the true and only Democrats. In reality, this is a strategy of obfuscation in order to hide the true face of totalitarianism that lurks behind. Where populists are in power, they do not shy away from destroying the democratic constitutional order and the democratic rule of law from top down. To meet this challenge, democracies must be and must remain vigilant. Wherever and whenever violations of democratic rules and of the rule of law occur, these must be clearly identified, consistently pursued, and sanctioned. Any form of indulgence is inappropriate and will be taken as encouragement. It takes, of course, courage and stamina to expose oneself to populist accusations and attacks and to oppose them resolutely. In addition, there must be a constant argumentative confrontation, not only with the political agenda of populists. This alone will not suffice. It must be clearly pointed out again and again that the premise of the populist agenda is false. The political will of populist movements is not identical with the will of the people. Populist parties legitimately participate in the formation of the will of the people, but they do not embody that will. It's not easy to draw a satisfactory conclusion. There is no simple panacea to counter authoritarian populism. Of course, democracies must defend themselves against their enemies. In this struggle, they always have to resort to the means of the democratic rule of law. In doing so, one must be careful not to use the tools of the populists themselves and provoke, threaten, exclude, personally insult, or criminalize. That would be falling into their trap and furthering their cause. One must seek objective debate and clearly take sides for the democratic constitutional order. It is not easy to take up this fight, but it must be fought. And it gets even more difficult when populists have already seized power and are undermining the democratic rule of law from within. This is where mechanisms of the European Union or the international legal community come into play. Even if these mechanisms appear ineffective, there's no reasonable substitute for them. Things remain difficult, but no one has ever claimed that democracy is an easy form of government. Thank you very much for your attention.
Thank you very much. This was captivating, and I'm thinking that something empty of content is not only poetic, but very strong. It's very difficult to beat something which can also take all sorts of forms and content. But I'm very glad that the focus has become not theory, but on what to do, how to take a stance, how to combat something. I think that this way we're getting somewhere. Now, and with this, I will pass the floor to Professor Koncewicz, Tomasz, who's also been living through this. He's from Poland. He's done extensive work on backslides. So I think it's a very good follow-up with Professor Haratsch's analysis. Tomasz.
Thank you. Like this? Okay, so thank you very much. First of all, a technical obstacle. I need to share my presentation, so hopefully we'll get there. Not Golden Gate Bridge, it's not part of my presentation. This is only desktop.
We're now gossiping, trying to see what you have on your screen.
Safe stuff. Okay. So do you see the presentation right now? Okay, so so I'm very happy to be here, and actually without coordinating Paul's presentation and previous presentation really laid the groundwork for my own analysis, because I want to move beyond the populism talk in a sense, but at the same time I want to anchor my analysis in many important messages that has been sent by my fellow panelists. So first of all, my working assumption is in my presentation, I really want to move beyond the boats, because the lawyers have this dangerous tendency on focusing on the boat. For example, Poland, boat A, Hungary, boat B. And at the end of the process, they forget about the journey. So they fail to learn about the common themes that actually bring the processes together. So my attention will be on the journey, and the journey will take me in 4 steps. First of all, I would like to understand who the enemy is. Secondly, I would like to revisit the European narrative in light of my identified enemy. My third part would be on Europe's critical juncture. My argument will be that the enemy, as identified in my presentation and as read against the background of what I call the first principles of the European integration, brings to the fore the very existential question where the Europe is and where it is heading. And finally, I would like to ask the question, so what kind of a journey are we talking about when we talk about Europe? So first of all, understand the enemy. It is really important to focus on a new paradigm that drives the smart autocrats. In the past, the autocrats were against liberalism and democracy. Today, they are in favor of democracy and they are against liberalism. And to do that, to deliver on this promise, they use the law in a very, very peculiar way. So the law is not to protect, but rather law is used to manipulate, to oppress, and to be used as a shield for the illiberal practices. So the law is used as a cover. So the autocrats do not signal their arrival on the scene with the tanks in the streets, with the mass violations of the human rights, as was the case in the past. No, quite to the contrary. They arrive on the scene with a set of smart constitutional amendments, very well-educated lawyers, and they go after the constitution and the institutions. So this change of paradigm in how we approach the law is really crucial in understanding how they operate. My second changing paradigm, and I think I will be drawing on Paul's analysis here, because I want to move beyond the politics of emotions, because we all feel emotions. We feel resentment, we feel anger, but what the populists do is to actually deliver on the politics of emotion. So they know that people are angry, but they deliver and they give a plan of what way we, the politicians, will do with your anger, how we will channel your resentment. So in other words, my understanding of the supply side of the populism, something that I call politics of resentment, is a constitutional doctrine that explains to the angry, resentful people why you've been failing, why the elites have been lying to you, and first of all, and most importantly, explaining what we will do now with all the failures of the liberal democracies of the past. So the politics of resentment go beyond populism, in my understanding, because the politics of resentment offer us a set of very concrete constitutional commands. We have a new understanding of the role of the Constitution. The Constitution does no longer protect the subjective rights of citizens. Rather, it expresses the uniqueness of the state. The rule of law no longer frames the decision-making process. Rather, it facilitates the expression of the will of the people. And sometimes liberal rule of law is seen as an obstacle in protecting the collectivity and the common good. And as a result, it should be rejected. Role of constitutional courts has been changed and is changing as we speak. So the constitutional courts in the liberal thought were always seen as those bulwarks of constitutional integrity, human rights, essence of constitutional rights. Within the politics of resentment, constitutional courts are becoming an accomplice in the delivery of the politics of resentment. They rubber stamped whatever the majority of the day decides. So rather than providing a check on the political power, they enable the political power. And finally, we have this dangerous trend of primacy of politics over law. We always knew, we the liberal-minded lawyers, we always believed and knew that it is the politics that should adapt to the law, not the other way around. And in the politics of resentment, it's always the politics that dominate. It is the law that should adapt to the politics of the day, which is the will of the majority. And if you have this understanding of the politics of resentment as a distinct constitutional doctrine, then revisiting the first principles of the European integration is a very sad and sober exercise, because Europe was always about learning from the past. Political power was supposed to be a political power constrained by the law. Constrained political power was one of the founding myths of the post-45 constitutional liberalism in Europe. We decided to come together with the European peoples because we always felt that the element of commonality is more important than the element of distrust, which was obvious given the past experiences. Democracy post-45 was to rebuild through law. So the law was to become this mechanism to replace the war as an instrument to regulate the interstate relationships. So integration through law and within law as one of the paradigm of this European project. And finally, what I called Europe and never again constitutionalism. And if you really go point by point here, you really see the extent of the clash between the politics of resentment and what Europe was supposed to be. Constitution was supposed to be supreme law of the land. Fundamental rights were supposed to be the barrier to any majority that is coming to power. Separation of powers was one of the governing principles of interinstitutional relations. Supranational adjudication, Court of Human Rights, and the European Court of Justice were to provide those extra external checks on the domestic political process. And finally, the ethos of membership. And I quote here one of the early decisions of the European Court of Justice. The member states were bound and still are bound to do things within the framework of the European law, within the framework of the European law, not in opposition to the framework, not outside the framework, but within the framework. So if you have those elements, then the obvious question comes to the fore. okay, so we have the clash between two competing constitutional doctrines. What should Europe do? How should Europe react to this? And first, I will emphasize that the clash between politics of resentment and the Europe's first principles, it's not just a crisis of governance. Because if Europe deals with a crisis of governance, it invents a new institution. And it's been so for the last 6 years. No, we have to move beyond this institutional tinkering, because what we are dealing with Poland and with Hungary, it is a crisis that affects the very constitutional profile of a member state, not a candidate state, a member state sitting at the council table in Brussels. This is our fellow member state. We are dealing with a value crisis that affects the very foundations of the European project, what I called the first principles. And the court has been very busy, of course, responding to those threats. And with the case law of the court, we might pose the following questions. Should we consider values are still being shared between all the member states? Is the authority of the law really a power that binds states together? Is it really one court for all the member states, since at least 2 member states reject the authority of the court in a repeated fashion? Those are all question marks, but the question marks bring to the table the seriousness of the situation we find ourselves in right now. So if you look at the Court of Justice, and this is really important point, how the court has been dealing with Poland and Hungary before, I think it has 2 sides to it. The perspective must be dual. So on the one hand, you have the logic of the courtroom that is alien to Orbán's and Kaczynski's of the world. Because in the courtroom, you have a language of legal principles that stand for the first principles of the European legal order. And the court is a very egalitarian space. One member state, one voice. Show me your arguments, and then I will let you know whether you have a chance to win your case. And that's why Orbán and Kaczynski are afraid of the court and the courtroom, because the courtroom will at least try to enforce the first principles against those member states. But this is the logic of the courtroom, which is only one side of the coin, because at the same time, we have the other side of the coin, because it is not just the Court of Justice that owns the fidelity to the first principles of the European integration. It's all the institutions, it's all the member states, because this judicialization of European governance has been always a joint enterprise. Every actor has a role to play. And if you look at the past 6 years, the picture that arises is extremely sober. Basically, it's been only Court of Justice that's been out there trying to do something, trying to draw the line and tell the governments, no, you cannot overstep this line A, B, C. The council has been missing in action. The commission, long story, don't have time to go into details. Only recently, the commission has been giving some signals that it has finally understood how to deal with the politics of resentment, but it's way too late. And the member states, well, the member states, a complete failure. The member states have become the enablers of Kaczynski and Orbán, because the petty politics at the parliament in Strasbourg won the day, because you want to keep the majority within the European Parliament, so you need all the votes. And Kaczynski's votes are important. So this is how you actually understand my rallying cry for show your fidelity to the treaties, show your fidelity to the EU law, because this is upon all of us. So finally, epilogue, and in the epilogue, I would like to be a little provocative, because I would like to move beyond the lawyers' hats. Again, this is in line with Paul's argument. So the question is, what kind of a journey are we talking about when we talk about Europe? So first of all, we have to understand that we are dealing with questions of not simply enforcement, not simply misimplementation of a directive. We are dealing with questions of identity and belonging. The question is this: are we the Poles, ready to live together and paddle together with others, honor our commitments, and live together peacefully despite our differences? Again, this is a question mark. We have to, secondly, revisit the understanding of the rule of law. So the rule of law was always implicit in the founding father dream of a unified and peaceful Europe. So what we are dealing today is the explicit expression of what the rule of law entails for you as a member state. Rule of law becomes an essential precondition for all parties to the European consensus as a precondition of your belonging to the European consensus. If you reject the minimum understanding of the rule of law as interpreted by the European Court of Justice, you are not a member state, even though formally speaking, you might still be a member state. So this polexit that I was writing about is more of a factual process that incrementally proceeds rather than a legal procedure of kicking Poland out of the European Union. Polexit is happening on the ground. If you put together all the developments that reject the rule of law as understood by the European Court of Justice, you have the polexit par excellence. And finally, moving forward, rule of law must be understood as a benchmark for belonging to the European public space. Show me your rule of law practice, and I will tell you whether you are a member, a worthy member state of the European Union. So finally, 1 minute. What about the future? So the future has one fundamental trajectory in place for us. The question that must be asked in the days to come is how the EU will be able to protect the essence of citizens' rights, not against the other member states, but against the states of citizens' own nationality. So enforcing the rule of law in our names, in the names of the European citizens, against my state that violates my citizens' rights. And it's a paradigmatic shift, to be honest. But if we really want to deliver on the promise of the first principles, this is where we must be heading. So finally, the right questions that should be asked as we move forward: when will, how, meet why? Today we have to remember why the European peoples came together in 1951, because we believed that being together is always more important than being apart. Because the commonality element was always there, shattered by war, true, but always implicit that we, the Europeans, share something special that is a bond. Second question: in the name of whom? In the name of whom the rule of law is enforced? The rule of law, the European rule of law, is enforced in the name of the European citizens. And whose rule of law? Not rule of law of the institutions, not the rule of law of the European Court of Justice, but the rule of law that brings peoples within the ever closer union among the peoples of Europe together. And this is my final slide, and it goes really in parallel with what Paul has argued. So if you really want to strike back against the populists, you have to convince the citizens that the Constitution is their Constitution. The Constitution becomes a social fact, a lived experience. The same goes for the treaties. So we have to go from the treaties to the social lives of the treaties, to explain to the European citizens how the treaties change their life. Here in Gdańsk, Gdynia, Prague, Athens, the treaties are a living instrument that work for you. And this is unfortunately when the European narrative and the European institutions are failing miserably. So on this very somber note, I would like to finish. But the time for niceties is over. The challenges are upon us. Thank you.
Thank you very much. This was very passionate and it connected so greatly with the previous analysis. And yes, it comes down to what will happen. And now that war is again upon us, and it takes us also to whether we need checklists. I don't know about what the rule of law is, because intervention, yes, but intervention and how and on what grounds? Do we have a solid ground on which to intervene or convince the citizens? Now, I will very quickly pass the floor to Kostas Botopoulos. Kostas, the floor is yours.
Thank you, Alkmήνη. Good morning or evening to all of you. It's a pleasure being with you and kind of representing not only Greece, but the Tsatsos Foundation as well. I would like also to say that it is an emotional moment because Dimitris Tsatsos has been not a teacher, but a master of myself and a dear friend. And I know that this applies to if not all, most of you, Andreas surely, but other people on the panel as well. And I would like to take a minute to think about collectively about Dimitris. And I will try to speak also thinking how Dimitris would have thought about those passionate issues we are all talking about today. So my point of view would be, and I hope this will not disappoint you, my point of view will be more legal than either sociological or political, but I think that it will link pretty nicely to what everybody has said. My focus would be on what I call judicial populism, populism that arises out of the jurisprudence, the case law, of both national, Tomasz, and international, and the EU tribunal, the courts. Incidentally, and it's a nice fit. One of the last articles I wrote for Συνταγματικού for the Tsatsos Foundation, let's say, newsletter, what Alkmήνη has explained that we are trying to focus on current issues, was called the de facto polexit. So how exactly the latest judicial developments are arriving at what you, Tomasz, have called the factual polexit, and not the judicial. But it passes from the court's avenue, if I may put it so, on which I will focus. So I will start from the assumption that the question of the European rule of law, incidentally, I prefer the French expression état de droit, the state of law. It's broader and it's more fundamental from what the Anglo-Saxons call the rule of law. It's not the rule, it's the state, it's the foundation. And I think most of you have already underlined this point. So the recent adventures that we are having in Europe, I think, have acquired a central political but also legal dimension of the rule of law. And this is a confrontation. Tomasz and also some of you have already underlined, we are not in an angelic world, we are not in an hypothetical world, we are not in a theoretical world, we are in the world of confrontation. Through breaches, open breaches of the rule of law, I would say that the most important issue is the fact that in countries such as Hungary primordially, but also Poland, and not only, Slovenia, which was 1 year ago at the head of the European Union, enacted against European Union, which is also a first for Europe, Romania, Bulgaria. Some countries are now openly acting against the European Union, so values. So one thing is breaches of the principles of the values, And the second thing is the putting into action of defensive mechanisms from the inside of the European Union. And this, Tomasz, unfortunately cannot be done either, I think, on a theoretical plane or from a citizen's initiative such as Paul has very nicely underlined. This cannot, I think, be done from below at the start of the situation at least. This must come from the European Union and most manifestly from the Court of the European Union, which is the first to react on those breaches. So breaches on the one hand, and open judicial confrontation on the other hand. And then based on that, I will make some three brief remarks on the supremacy, on the issue of supremacy of law and liberal democracy, and on other ways, more subtle ways, more financially oriented ways of circumventing the breaches of law, because we are, as Europeans, in a commonality of values, but we are mostly, dear friends, in a commonality of money as well. And financial sanctions can play a very important role. And of course, I will be referring to the new rule of law mechanism, which is a rule of law mechanism that has to do with financial sanctions. And my last point would be to compare this European judicial populism, as I call it, with two other forms of judicial populism. One coming, if I may, Andreas, from the Bundesverfassungsgericht, from the case law of the German Constitutional Court, and another one, and it was mentioned at the beginning by Alkmήνη, the US example, another kind of judicial competence coming from the US. So to jump in the main points I want to make, a legal confrontation. Breaches in many countries, as I said, Poland, Hungary, mainly on judicial independence. This is the case, most importantly, of Poland, but also of Hungary. But, and it's very important, also minority rights, freedom of press, also some examples, most notably in Hungary, how to deal with the pandemic, how to curb minority rights with the legislation passed in the pandemic. And again, open breaches. Poland and Hungary are not saying, and in a lesser degree, Romania and Slovenia, are not saying we do not want to breach the EU law, the EU values. They say we are breaching EU values because we think that they are not compatible with Polish, Hungarian, Romanian constitutional and political principles. This is a very important issue to my eyes. This open confrontation and this open battle around the EU values. And this, the Polish case is exemplary. This has led to constitutional changes. Poland has made very large constitutional review around especially judicial independence, with texts of law having passed through the parliament enshrining a new disciplinary process, a new way of choosing judges, both in the Constitutional Court and in the other courts. And finally, and from a legal point, most importantly, two very important and very difficult to digest, if I may put it so, decision by the Polish Constitutional Court on October 21 and on March 22, whereby it was judged that in the first one, for the first time in the history of the European Union, that the EU treaties were incompatible with the Polish constitution, and in the second one, that the European Convention of human rights was incompatible with the Polish constitution. So again, a very open confrontation on that. How did the EU respond? With political and judicial means. The political means, we all know, has been first recommendations. What are you doing? You must change. This is not according to EU principles. This is not independent, judicial independence. You must change the laws that you are taking. And then, for both countries, for both Poland and Hungary, a breach of law procedure according to Article 7 of the article about systematic violation of rights in the European Union. But most important, I think, and there's my point also about the importance of case law, of jurisprudence, of the work of the courts. The most important response, if I may put it so, was by, of course, the European Court of Justice. First, in a series of decisions, 219, 220, 221, saying that the disciplinary chamber of the court was not impassioned, the disciplinary procedure that came by with the legal changes was not legally correct, that the whole, this is very important, the whole functioning of the Supreme Court was not according to the EU values. So for decisions to that effect, and two very important generic decisions by the EU court. The first one on the 3rd of February 22, the famous Advanced Pharma decision, whereby it was judged that the whole Polish judicial system had systemic failures vis-a-vis European values. And the second one was a judgment on the 16th of February 22, very recent judgments, about the legality of the rule of law mechanism, to which I will come in a minute, whereby it was also judged that there is another way to try to circumvent legally, but also politically, the breaches of the rule of law in this country. Let me finish this first point with, to my eyes, very interesting change that has happened. With the war in Ukraine, the situation has changed dramatically vis-a-vis those two main breaches of European values. Poland, because of the acceptance of the refugees, 3 million and counting, Tomasz, if I'm not, if I have the right numbers, because of the fact that they are very much for very broad sanctions, because of the Prime Minister's visit to Kiev, because of their overall stance in the Ukraine conflict, are a bit now out of the bush in the rule of law question. They are not pushed that much. They are saying that even the rule of law mechanism could apply under certain conditions. And on the other side, Hungary, because of Orban's stance, because of all the things you know, is now being very much to the forefront and pushed by the Commission. And it's only against Hungary that the rule of law mechanism has been very recently, last week, started and triggered. So it's an interesting, I think, mix of law and politics again, which is, of course, a preeminent feature of constitutionalism. When we speak of constitutionalism, we have in mind this is Tsatsos' main, if I may put it so, main lesson to all his pupils: politics and plus law equals constitutionalism. So a few words about the interesting also, I think, differences within this frame between the issue of supremacy, which is more important, which has legal supremacy, the EU law or the national laws. This is a question that has been again in the forefront, especially through the Polish Constitutional Tribunal judgments, whereby they said openly again that Polish law has precedence, that the EU treaties would come after Polish law, and Polish constitution is foremost, and EU treaties and the European Convention of Human Rights come after. I think that the supremacy issue cannot be dealt with, and there I am completely in agreement with all of you, I think, cannot be settled by the courts. The courts can say, and the European Court of Justice has said it in so many words, that of course the supremacy is in the European, in the treaties and in the European law. But since there is no mechanism to impose such a judgment other than starting again the infringement procedure, which is not an interpretative judgment, and then the national courts can have their own interpretation.
Kostas, I will ask you to start wrapping up in 1 or 2 minutes, so that we will all have a chance to say a few things before we wrap up. Okay.
I need 3 minutes, please. I need 3 minutes because it will be...
Okay, 3 minutes.
Okay. So,
but I can't promise you will have a second chance.
Okay, let me wrap up, and then I'll take also my second chance.
Okay, okay.
Then if I have the third, I'll take my third also. I've seen Xenophodas on the screen, so
yes,
I know that I'm hard pressed. So let me try to conclude. So, to my eyes, the supremacy issue or the liberal democracy issue, to which many of you have alluded, cannot be sufficiently clearly solved by the interpretation of the courts. Then comes the rule of law mechanism, which, because it has financial sanctions between brackets, and because it is not subject to a veto, this has been the political battle won in the European forefront, the fact that the rule of law mechanism passed by the unanimity, but within the mechanism, we have the rule of qualified majority for decisions. I think that the rule of law mechanism is a very practical mechanism. I finish, Alkmini, with your permission, with 2 words on the other 2 kinds of judicial populism. The one, without many details, the one which I would call aristocratic way of thinking comes from the Bundesverfassungsgericht in the famous decisions, especially the 5th of May decision, whereby it says not that the German constitution has supremacy, but that the European law should be interpreted in the light of the German constitution and by the German constitutional judges. And the second one, and I'm finishing with that, is the US approach, the recent and infamous Alito draft that we've seen, but which will most probably bring a Supreme Court decision on the right of abortion, whereby the American judges use the so-called originalist approach, what I would call a backward majoritarian approach, whereby rights such as abortion, minority or even majority rights that were not enshrined as such in the first constitution 2 centuries ago, and if they do not reflect what the judge and Scalia before him called the deeply enshrined traditions of American law, let's go and find what does this mean, which are the deeply enshrined. Those are outside the remit of protection of human rights, whereby this, and this is my last word, this is also a kind of populism. This goes against, I think, democracy. It goes against logic. It goes against constant change, which is a must, I think, for constitutional thinking to once again think what Dimitris Tsatsos would probably say in this issue. Thank you very much, and sorry if I took one.
Thank you, Kostas, very much. We started from sociology and we are ending with judicial populism, a new form of populism perhaps that lurks there. So I think since we don't have much time, I will start rotating the floor again. You each have 2 minutes to say a few comments, to wrap up, to respond. And I will also welcome Professor Xenophon Kondiadis, who sneaked in. Welcome, Xenophon. You want to say something, Xenophon, or I will pass the floor to Catarina Santos Botelho?
Please continue.
Welcome.
I have to close the Congress in a few minutes. Thank you.
Okay, great. Catarina, the floor is yours.
Thank you so much. It was such a delight to hear such different approaches to populism and the challenges of the rule of law. Perhaps one aspect that I think it's relevant to highlight is that we should not demonize the elector. The electorate? Why does the electorate makes what we think are bad choices? Perhaps their concern or their concerns might be imaginary, might not really exist, but we should address them. And liberal democratic societies must bring these subjects that, even if they seem to us lacking a lot of logic, but they should be addressed within the democratic arena. And because we all know that better arguments and discussing things, it's has a quite positive outcome. So that would be my comment. Thank you so much, Alkmήνη.
Thank you, Catarina. Thank you so much. Paul, you have many questions open, I think, there.
Yeah, but I can't address any of them, I suppose. I just wanted to end on what I believe was the most important observation made today by Tomasz on the insight that ultimately here we're not talking merely about backsliding boats, as Tomasz called it, but we're talking about a deep problem within the European project as such. And if we don't start addressing the problem in this manner, it won't go away. And it can be done just by the court. The court has done a lot of things to put itself in the limelight over the course of the European integration process. But ultimately, we're talking about a political project that has formulated its fundamental values, but then it doesn't really manage to make them part of a societal project. And so I think this is really an important point that we should all take up in one way or the other and think about how the European Union might be drastically reformed in a manner that indeed citizens understand its very important role in keeping democracy in shape. Thank you so much.
Thank you so much, Paul. Professor Haratsch, please, you have the floor.
Yeah, thank you very much. Thank you for the lectures of today. I've learned quite a lot now. What I would like to stress 3 points, which I think are very important. And the first one is what I've learned from the lectures of Paul Blokker and of our Polish colleague Tomasz Koncewicz. This is that we need the civil society in order to protect the rule of law. It's not only the state institutions who can do this, but you need the civil societies, and this is indispensable. And I think it's a kind of socialization of the people. They have to understand what the rule of law is, what its worth is, and that it's worth fighting for it and protecting it. This is the first point. I think this is really crucial. The second point is, and this is really tragic, and I think the words of Tomasz Koncewicz have stressed it very much, that the principle of the rule of law has become negotiable during the political process of the European Union. And this really is tragic. because this is one of the big mistakes of the European Union and of the construction of the European Union. You need the votes of certain member states, and in order to get the votes, well, you have to cope with the breach of the rule of law. This is really remarkable and makes me not very optimistic. And the third point, a very short one, concerning Konstantinos Botopoulos. Well, I agree. The judgment of the Federal Constitutional Court of Germany on the PSPP matter, on the ECB acting ultra vires and contradicting the German constitution, was a big mistake, because everybody knows, and the judges know that too, that of course the German Federal Constitutional Court is a role model for other constitutional courts, and if the German court renders such a judgment, other courts will do it in the same way and will use it in order to follow their own agenda. And I think this was a real big mistake and, well, tragic. So thank you very much. It was a pleasure to be here, and hope to see you again in Athens or at some other place. Thank you.
Thank you very much. Hopefully, yes. Tomasz, please.
I will be very short. A few wrapping up comments. First of all, what is the European consensus all about? European consensus is not about unity. It's about a controlled diversity. So European consensus is an overlapping consensus. We, the European peoples, accept certain way of life of others, certain constitutional essentials as our own sine qua condition to be bound by the laws adopted by others, not in our name, and yet laws that will affect our lives as well. So it is important because Rawls has always argued that from the overlapping consensus, you have to ban from the outset the interpretations that are unreasonable. And what Poland has been proposing in terms of understanding the rule of law, judicial independence, etc., has been unreasonable from the perspective of this minimum constitutional essential that the rule of law stands for. And the minimum is this: you cannot fire judges overnight by fax. There is a common standard of judicial independence that should be guaranteed across the board by all the states parties to the European treaties. That's my first remark. My second remark, I think it is really important that we lawyers should be careful about the language we use. Polish Constitutional Court, it's not a court within the meaning of the European law. So when we make this argument, there is a conflict of courts, we give the credence, we give the credibility to a body that is not a court within Article 6 of the European Convention of Human Rights. We should be very clear about this, because if not, then this business as usual and referring to Mr. President of the Court of Polish Constitutional Court will be anchored in the public consciousness of the people. In 1 year time, they will think, oh yeah, nothing has changed, the court is still there, so it is Constitutional Court. But the heart of the Constitutional Court has been ripped out. So it's not a Constitutional Court. And my third point, if you really want to have a dialogue or a conflict between constitutional courts, something that has been inherent to European law, you have to assume that there is a good faith element between all parties to the conflict. Polish Constitutional Court, in opposition to the German Constitutional Court, does not share the element of good faith. It rejects the very basic foundations of the European integration. It is not interested in negotiating a good-mannered, reasonable compromise. It is simply placing itself at this no position, radical no position. And finally, since we are in Greece, let me refer to one of my absolutely favorite judges of the European Court of Justice, former late Greek judge Konstantinos Kakouris, who was once called a most poetic judge in Europe, and he referred to the European Court of Justice by using the word ethos. So the ethos of the European Court of Justice has been always to make sure that the interpretation and the application of the treaties, the law as an idea of law is ensured. We are not talking about respecting the technical provisions of the treaties, but we are speaking about upholding the very rule of law, the law in Article 19 of the treaties. And sometimes it's very, very useful to revisit the old writings of the former judges of the court, because in my understanding, this is where the true promise and unfulfilled legacy of the European project reside. Thank you.
Thank you very much, Tomasz. Kostas, one word or two. We can't hear you. You're muted.
Sorry. Very briefly, I'm glad that Tomasz indirectly agreed with me in saying that finally what the European Court of Justice has said, Tomasz, is that the Polish constitutional law is not a court. That's what the European Court has said, enshrined it in a decision and put it in front of the faces, the minds, and the eyes of 100 million European people. That's my point, that the court has this role to play, and then comes, of course, the politicians. And I'm sorry that in Hungary, the politicians who were against Europe and against the rule of law have won again. We have elections in Poland coming. We will see what happens. But I'm not in favor of saying that the people have always right. The judicial independence and the role of the court is to say what is right from a legal and an ethical perspective, and this is very important. And Mr. Kakouris was a dear friend of mine, so it warms my heart to hear you say something about Kostas Kakouris. So that's the role of the courts, to put in front of the eyes of the people what is the right interpretation of the law, which means of democracy, because the law is the foundation of democracy.
Thank you very much, Kostas. Thank you all. I feel I need to thank you all, and I feel quite optimistic in the sense that theory has started to focus not on just analyzing the phenomena, but actually trying to find what can be done to address the problems. And I think this is a great new step for constitutional lawyers and sociology, of course. Thank you very much, everyone, for being here.